if it is drafted pursuant to what is allowed under the statute, and if it's drafted in conformity with existing case law. One of the things where businesses run into trouble is when they'll grab a form off of the internet and they won't have an attorney look at it, and it may be valid in some states and not valid in others. But one of the criteria for enforcement is whether or not the non-compete is reasonable in the scope of the limitation in regard to the type of activity that's prohibited, in the scope of the geographical area of where the prohibited conduct would be applied, and it has to be reasonable in relation to time frame. So you can't have one that lasts for an unreasonable period of time. And there are presumptions in the statute for time frames which are will be deemed to be reasonable or unreasonable, but those are rebuttable presumptions. So you may have one that actually is over that time frame, but you could explain to the court that there's a good reason for having one a little longer than what the rebuttable presumption would be as far as what's reasonable and unreasonable in time. So there are restrictions for geographical location, for restrictions for the amount of time you can enforce a non-compete for once an employee has left employment, and also too in the scope of what the actual activity is. So if that's been drafted properly, then a court most certainly will enforce a non-compete. And if they don't, then they will probably be reversed on appeal.